Hi, I'm Libby Roof, Chief Communications Officer. Thank you for being a part of the Lexington One family. After you watch this video, you will be asked to sign a confidentiality agreement, something all employees have to do every year. Do you ever wonder why we have to sign that agreement annually? Let's find out. Every single employee in our district has the important responsibility of protecting students' privacy in accordance with the federal law that we refer to as FERPA, which stands for the Family Educational Rights and Privacy Act. This law protects the privacy of students' education records and gives certain rights regarding those education records to parents or to the student when the student turns 18. To answer our question about why we have to sign a confidentiality agreement, we are going to focus on the first part of the law, protecting student privacy and the confidential information that makes up a student record. For more specifics about the rights afforded to parents and students by FERPA, please review our board policy JRA Student Records and the administrative rule JRA-R, which you can access along with all of our board policies on our website. Simply go to www.lexington1.net. Under About Us, click on School Board. Then click on Board Policies. Once the board policy manual comes up, click on Students and scroll down under the selection of policies under Students until you find JRA and then JRA-R. All right, let's start by making sure we are all on the same page with a few important key terms. First, student education records. This is information directly related to a student and maintained by the school. Our administrative rule for policy JRA provides a list of what is considered to be part of the education record. The next term is personally identifiable information, or PII for short. This is information in the student record that requires written consent from the parent or eligible student before it can be released. Spoiler alert, there are some exceptions to that rule. Remember the term legitimate educational interest. We'll come back to this one. But first, let's jump right into one of the most common exceptions, which is referred to as directory information. Directory information is information contained in the education records of a student that would not generally be considered harmful or an invasion of privacy if disclosed. The FERPA law allows this information to be disclosed without written consent as long as the school district tells parents every year what we define as directory information and gives parents the opportunity to opt out of this information being disclosed. This is something we do every year in the annual registration process. In the administrative rule for board policy JRA student records, Lexington One classifies the following student information as directory information: name, address, participation in officially recognized activities and sports, weight and height for students who are members of athletic teams, dates of attendance, diploma or certificate and awards received, grade level, most recent previous school attended by the student, photographs that can include digital images, images on videotape, and other electronic images as related to school-sponsored or district-sponsored events, and other similar information which may appear in newspaper articles, on television and radio broadcasts, on displays, on the internet, on district or school promotional pieces. The primary purpose of directory information is to allow Lexington One to include this type of information in certain school and district publications as a way to recognize students and promote their achievements. These publications include, but are not limited to, the annual yearbook, school and district newsletters, programs for school events, honor rolls or other recognition lists, school or district website, social media channels, news releases, media coverage. You get the deal. During annual registration, parents tell us if it's okay to release any of this information, none of this information, or some of this information. Their responses are stored in PowerSchool so administrators, teachers, and other school employees can check before releasing any of the information about our students. Please make sure you know how to access this information for your students. Ask a school administrator if you do not know how. Okay, it's time to circle back to that important term I asked you to remember. You got it? Legitimate educational interests. So here is an interesting question to think about. Can any employee in the school district access a student record without consent from the parent? Did you answer no? If so, you are right. And here's how the feds explain that answer. FERPA permits a school or a school district to disclose, without consent from the parent, personally identifiable information from the student's education records only to school employees who have legitimate educational interest in the information. Generally, a school official has legitimate educational interest if the official needs that information to do their job. So, in other words, if an employee doesn't need to know something about a student to do their job, then they can't access that information in a student's record without the school first asking the parent's permission. Now that we have covered the background information that explains the why for the annual confidentiality agreement, let's review. We sign the agreement each year to acknowledge the following. First, that we understand our very important responsibility of protecting private, confidential student information that makes up a student's educational record, and that this responsibility is required by the Federal Family Educational Rights and Privacy Act. 2, employees can only access private and confidential information about a student if they have a legitimate educational interest, or in other words, need that information to perform their job responsibilities. By signing the agreement, you are also acknowledging that there are serious consequences for not upholding the agreement. These consequences include a parent or eligible student may file a complaint with the U.S. Department of Education's Office of Family Policy Compliance. Employees could face legal action and/or disciplinary action, including termination. The U.S. Department of Education could withhold federal funding from the school or the school district. So far, we've talked about why we signed the annual confidential agreement and what happens if you violate that agreement. Now, let's talk about how you can avoid violating the agreement and stay in line with FERPA. Remember to check PowerSchool before releasing any student directory information. Don't have conversations about students and their families in public and with people who don't have a legitimate educational interest in the information. Avoid posting, sharing, commenting about students and their families on social media. If you hear something about a student that is concerning, share that with your school administrator and follow their directions on how to respond. Don't have casual conversations about students and their families with other employees, students, other families, your friends and families, before, during, after work, at school, or away from school. Protect your students' private information just as carefully as you would want your credit card company or your bank to protect your personal financial information. Oftentimes, the best way to show you care is to not share. If you have questions about FERPA, privacy laws, directory information, do not hesitate to email me or give me a call at Central Services. Our entire district's communications team is here to help you with this important responsibility. Thank you.